Welcome. I'm Bernice Ross, the CEO and President of BrokerageUp and RealEstateCoach.com. And I'm very happy to welcome James Dwiggins, who on August 9th, 2023, I interviewed him, and everything that he said in that interview has just happened today with the $1.78 billion verdict against the defendants in the so-called bombshell lawsuit litigation. James, so what you want to do with us today, first of all, is that you're going to walk us through what we need to do right now in terms of all the different layers of the industry and what the outcome will be. And it's not as gloom and doom as a lot of people are thinking. So James, I'm just going to turn this over to you. You called it all right. Where do we go from here? What do we do next?
Yeah. So first, thank you for having me, Bernice. Certainly I wish I was here under different circumstances and not, having my predictions correct. I wanted to be wrong on those things, but I guess we'll start with the idea that, that everyone needs to just take it down a notch to begin with. I don't have this viewpoint that this is the, end of our industry, like a lot of the headlines are saying, et cetera. I think it's important to understand that there are go forward strategies that we can deploy as an industry. We've outlined a lot of this stuff, including in the interview that you and I did in August. And certainly that strategy still exists today. I think what I'm going to do is recap just real quickly sort of where we are, what you're likely to see next, and then I'll give a go forward plan. And there's a lot of notes I have here to go through because there's a lot of stuff that's moving very quickly in this process. So the first thing I want everyone to remember here is the damages portion that you're going to hear about in these cases is for the most part irrelevant. It's a weird statement, but you have to remember that plaintiffs have already signaled that they want to settle these cases. They've gotten into a room. And by the way, this isn't just Burnett. You have obviously Burnett, you have Morrell, you have No Select. All three of them have been in the same room with Remax and Anywhere and have settled cases. So you have all the lawyers in the same spot negotiating on a settlement. In addition, those settlements were a nationwide settlement. The class was opened up beyond just the 20 markets of Morrell and this one market, which is today in Missouri. They've opened it up nationally. So Anywhere and Remax have settled these cases for approximately $55 million on Remax's side and $83 million on Anywhere's side. And they opened the class nationwide. What that means is everybody across the US can essentially join the class and gets a small amount of money from these settlements. So it's very important that everybody understands when you see these big numbers, the plaintiffs' lawyers are not trying to bankrupt these companies. That is not their intent. They have already signaled and have agreed to settlement amounts that were much lower than most of the pundits have been talking about on these cases. Why I want to make that point is just because it says $1.78 billion, that doesn't mean that that's the actual amount that the industry is going to have to pay. If the companies can't afford these settlements, the only option for them would be bankruptcy. Well, that doesn't do anything for the lawyers who want to get paid or their clients. So my first comment is take these numbers with a grain of salt. These numbers are going to be shrunken down into a number that the defendants can actually afford. So that's the first thing I want to make sure that we get across, because everyone's going to be like, oh my God, what do we do? And the reality is these are just the amounts that were awarded. Now comes the negotiation part. On that same piece, so obviously you're going to see NAR and others appeal this case. My prediction is that's irrelevant also. The reason why it's irrelevant is they can't afford to continue on with this and going through another multi-year appeal. And at the same time, they have to post a bond that will cover the damages portion of these cases. So you can't appeal and then during that process, essentially lose all of the assets, and then the plaintiff will have no way to collect those damages. So they're going to have to post a bond in order to cover that $1.78 billion. Theoretically, I don't know the finances of those organizations, but maybe they could cover the bond. If they can't cover a bond of that amount, then they have a serious problem. The point here more than anything is during that 30-day period where they're going to look for a bond to do this, I think you'll see a settlement occur. The reason why I'm sharing that with you is, as we have predicted, you'll see copycat lawsuits ensue, which were filed about 30 minutes after the judgment was done. The same lawyers filed another suit against EXP, Compass, Howard Hanna, United, and some others that was filed immediately after they got the judgment. These are the copycat suits that we've been talking about will ensue. And candidly, they'll keep suing everybody until we settle this whole thing out. So what I want to make sure everybody understands in this process, you're going to see these things occur. It's going to be scary. It's going to sound scary. But what is going to happen likely now, at least they better do this, is NAR is going to sit down and come up with a way to settle this case on a national basis. What that would look like, this is simply a speculation. It could be formed in a lot of different ways. But NAR basically says, okay, we're going to settle this case because they're going to keep suing everybody. And we're going to come up with a number. And then they agree to this number. And in theory, NAR would do some type of dues assessment to help cover those damages that would occur. Let's just hypothetically say that the defendant NAR in this particular case agreed to a $2 billion settlement. Sounds big, I get it. But if you do a dues assessment over 1.4 million realtors or whatever that number is over the course of a period of time, it's not as much money as it sounds. Then you have people going, well, I don't want to pay, it's $500 a year. Screw that. Well, let me tell you, you should take that deal every day of the week, because if you've ever been sued, spending $1,600 or $2,000 in a settlement number is literally 2 hours of a lawyer's time when you're being sued by another organization. It also, I think you will see, again, my speculation is NAR will make the settlement based upon NAR membership. So if anyone is thinking about leaving NAR because of this, do not do that. That would be a tactical mistake on your part until you see how some of these negotiations occur. Again, all speculation, but logically makes sense. The plaintiffs has already shown they're going to sue everybody else. They just filed that suit today in Missouri. So they're going in the same court. They're bringing everybody else into these suits. They're going to do that and continue to push the industry to settle the case out. I firmly believe you will see NAR settle this case. They're going to get a lot of pressure from the industry in order to do that. And they'll come up with a global settlement or nationwide settlement. What that means, before I move forward on what we need to do, is they open the class to everyone in the United States. So everybody who sold a house during that time frame can join the class and receive some amount of money. You've all seen a note card come in the mail where it says you're part of a class action lawsuit. Technically speaking, you're in the class automatically. You would remove yourself from the class if you didn't want to be part of the settlement, is how that works. And if you removed yourself from that class, then you would have a right to go sue essentially for, potential damages. That's unlikely, because once you open the settlement up and the defendants have come to the table saying we can afford this, if you file another suit and you join another class, in theory, there's no money left. Most lawyers wouldn't take those cases. So this is our go forward strategy that I think the industry needs to get behind and candidly put pressure on everyone to do. There needs to be a settlement. It needs to happen now. I'll stop there.
James, you've been speaking with attorneys about this. This is what the attorneys, because your company obviously is a company that could be at risk from all of this. And so you're getting advice from a lot of attorneys, but everybody I've been talking to, and I know that you've been talking to, has been saying NAR was going to lose the lawsuit. And I don't know how that plays out with the companies and the associations, but going forward, what's next?
Yeah, so what has to happen next is, as I just mentioned, NAR needs to settle these cases and get everybody covered through the settlement. Has to happen, because all these copycat litigations are just going to continue. The second thing that needs to happen is associations need to take a more proactive role in structuring things for the future. So I want to be clear what the plaintiffs want, what the DOJ wants, what the FTC wants, is a clear separation on who is responsible for who, meaning a buyer's agent is representing the buyer, the seller's agent is representing the seller, the buyer's agent's paid by the buyer, seller's agent's paid by the seller. Now, there's a little bit of workaround on that I'm going to get to in a second, but what they don't want is the seller's agent collecting compensation from the seller for both them and the buyer's agent. That is very clear on what the DOJ, the FTC, and what the plaintiff's lawyers have laid out. So the way this needs to go, the way that we all see this, that I've been talking to in the industry, is this. Right now across the US, 12 states require buyer-broker representation agreements that you have to sign before you, at the very least, write an offer on a property that's in the MLS. So 12 states currently require that. I think you should see 38 other states implement the same thing. local associations or statewide associations need to legislatively go down the path of getting that implemented at the state level. So that essentially when you are a buyer's agent and you're meeting with a buyer, you're establishing a relationship through a contract. You're saying, this is who I work for. You're establishing fiduciary, like you're basically saying, this is who I represent. That's to essentially skirt other practices that we've put in place over the years. So some of this is going to sound scary for some of you, but like transaction broker or sub agency, these are the things they don't want to see any further in the process. So right off the bat, state associations need to get together right now and go and work on, at the state level, getting a buyer broker representation agreement implemented as state law, like 12 other states across the US currently do it today.
Question for you, James, because I worked in California. There are very clear-cut agency laws in place in California regarding this, but this is not what you're talking about. Is that correct?
Correct. Yeah. Yours basically why the feds don't have an issue with a buyer broker representation agreement is because our industry has done things to skirt establishing fiduciary over time. This is where I would argue that our industry has set ourselves up for this problem. What they would love to see is a buyer's agent saying, I work for you. Think of it this way, like a lawyer. A lawyer doesn't represent both parties. They represent one party. And I'm not suggesting that we become lawyers. That's not what I'm saying at all. But they want to see the structure operated that way. And so they want to see this in place. It tells a buyer who's responsible for who. It helps the agent. And by the way, the third person that helps when you do that is the seller, because you're not having a bunch of looky-loos come through your house that aren't actually serious about buying property. So that's the first thing. The second thing that needs to happen immediately, in addition to setting that up, is NAR must be working with Fannie and Freddie on figuring out a way that compensation for the buyer's agent can be financed in the loan. You can certainly do it in certain loans today, but like VA, you can't. There needs to be changes that are put into place. This is what NAR does very well. This is one of the things that our industry needs to pay close attention to and why NAR exists. They're very good at lobbying. That is one of their core strengths. This is where they're an advantage to the industry. They need to think long-term and strategically about how we can provide opportunities for the buyer's agent's compensation to be paid when a buyer is already strapped for cash to begin with. This leads into the other two parts. This is why everybody needs to calm down, okay? You're going to see this structured in such a way where it is unconstitutional for the government to tell a seller what they can and cannot do with their money. So let me be very clear about this statement. You cannot tell a seller that I can't offer a credit in a transaction for something. We do it all day, every day, okay? So here's the three ways this will likely go. You're gonna see buyer broker representation agreements standardized at the state level. I think you should do it at the MLS level. That's a different conversation, but at the state level, it gets done. Number two, you'll have the ability to finance that commission or compensation into the loan. The most common thing you're going to see, by the way, is not that the buyer is actually necessarily financing it in the loan. You're going to see the buyer's agent stipulated in the purchase contract that the seller's to pay the buyer's agent's compensation directly, which they can do. We're just bypassing the seller's agent and allowing the seller to pay the buyer's agent directly. Or the third thing would be the buyer's agent can also write a stipulation that the seller provides a credit to the buyer, and then the buyer can pay the buyer's agent directly. So there's three different ways that you can do this compensation to the buyer's agent. And now I want to be very clear with this. If people go, well, it's going to put pressure on the buyer's agent. Well, I disagree with that wholeheartedly. Yes, we're going to have to learn how to articulate value to a buyer, and I'm going to cover that in just a minute. But more importantly is, if you look at the statistics of today, in 1960, 30% of Americans had a dual income household. This is a really important stat. Today, it's between 60 and 70% of Americans have a dual income household. Mom and dad with a kid don't wake up and go, we need to sell our house. Let's go do it all on our own, when we both have careers and a child and all the things that go with that. As Americans have proven, we're willing to pay DoorDash more money to deliver our food than the food costs because we want convenience and we're willing to pay a premium for service. I wholeheartedly believe Americans, and proven by studies, even 1,000-watt consulting's done. Brian Boera and the group had a great study that showed what their value is to consumers. Consumers are willing to pay buyer's agents. They're willing to pay seller's agents. They actually, most of the time, don't disagree with what they're getting paid. We just have to articulate it clearly. So I think you're going to see just a simple shift in the way we negotiate and the way that compensation is moved through the transaction to make this happen. It's a choice at that point in time. The fourth thing, sellers agents must sit down with their seller and explain to them, this is how it's worked for the past 40 years. This is likely how it's going to be or is. I'm going to get to this in just a moment. You need to understand that it's very likely that the buyer's agent's going to write in the purchase contract that you have to pay their fees directly. Mr. and Mrs. Seller, it's been this way for 40 years. You need to understand that the buyer's paying 3 times more than what your house was worth 10 years ago. They don't have the money to come up front with those commissions to pay their buyer's agent. So you need to be prepared to pay the compensation to the buyer's agent. And if you do not or are not willing to do so, there's a chance the deal could fall apart. A seller is going to come up with that amount of money to pay it. Here's another stat that's super important. I've obviously done a lot of research on this. 8 to 10% of properties in America are done via FSBO. 50% of those are done through neighbors or families. So I kind of discount that out of the mix, which means really 4 to 5% are done via FSBO in the United States, proving they're wanting to work with an agent to begin with. And number 2, most of those cases, having done this study in my own company, when a buyer's agent writes an offer on a FSBO and puts in the contract that the seller is to pay them that compensation, the seller goes, I'm not paying it. And they're like, okay, well, we don't have a deal. And what do you think the seller does 9 times out of 10 when they're a FSBO? They pay it. So my point here is there's going to be some shifts in this. The most important thing you need to be prepared for, and this leads into everything I just talked about, is a offer of compensation in the MLS is likely going to be banned. That's what everybody needs to understand. We have moved it, and everyone's moving from a penny or a dollar for an offer of compensation to now 0, what we call optional. I do believe that you will see compensation in the MLS be outright banned, that you're no longer allowed to offer compensation through the MLS. Now, why I say that is both the plaintiffs are going after that. They're looking for that in these cases. The judge themselves, both he and she, have indicated they want to see more. And the most important part is the Department of Justice has intervened in the settlement in NOSELEC and has basically said the proposed settlement between the plaintiffs and Anywhere and RE/MAX did not go far enough. They used the Northwest MLS where compensation in the MLS was already optional. I mean, you could put 0 in, and they said it doesn't go far enough. So what's super important for everybody to hear that I'm telling you is regardless of how these civil cases play out, you are very likely going to see the Department of Justice and the Federal Trade Commission get involved and find a way to remove compensation being offered in the MLS, which now backs up everything I just told you. You have to prepare to train your agents, and agents who are listening, you need to prepare how you have these conversations with sellers, and you need to prepare how you're going to sit down with a buyer, explain your services, how you're going to structure contracts in this potential, post world. I do firmly 100% believe this is going to be the outcome. It's simply a matter of time. That's what we're facing.
Now, James, question for you, because we're going into a market right now that is a skills-based market, and it's one, essentially, I think we're looking at a downturn just with the high interest rates and everything that's going to be pretty pronounced. So what has historically happened in every one of those markets, sellers have increased the commission that they pay to buyer's agents to attract clients. So is a possible workaround, well, maybe I don't put compensation in the MLS. I can't do that, but can I say buyer bonus, or, what prevents me as a seller from offering that to get people to my property?
Nothing. The only thing that you won't be able to do is have the seller's agent collect that compensation and remit it to the buyer's agent. That's the difference. The seller has every right to do what they want to sell their home. The rule will simply be that the seller's agent can only be compensated by the seller and cannot compensate the buyer's agent. They're just breaking that tie. So to your comment, Bernice, whether it's a bonus, whether it's an amount, whether it's a percentage, all of that can still be up to the seller to make those choices. And to be clear, if the government tried to intervene on that, that is A, unconstitutional from what I've talked to every lawyer about, and B, it would be fought in court and they would lose. So
are you saying then that we may be able to kind of continue business as usual by offering compensation if the seller chooses to do it?
Agreed.
But it has to be, so the buyer could negotiate directly with the seller for their compensation.
Correct. Which is what I was
So
just
it just, so it would be,
Correct. And the
so,
seller's agent should emphasize to the seller why this is important. And I'll give you a good example of if you're sitting down and to be clear, some of these things that you're going to see come out of this, there's going to be disclosures where the seller's agent has to sit down with the seller and explain that commissions and compensation is negotiable. That's going to be something that we're going to have to explain. It's going to also say that you don't have to offer any type of compensation to the buyer's agent. That's going to be also in the disclosure. That doesn't mean you still can't explain to the seller why it's important to do it and what is going to happen and likely how it's going to be put in the purchase contract and all of those things. It's just the best example I could give is think of after, for those of you in the industry, after 2008, when Dodd-Frank came out, there were all these new disclosures and rules and regulations on mortgage. And everyone was like, it's the end of the mortgage broker. Nope. We just adjusted. We just adapted. And we learned to articulate value better and differently and still explain to consumers what we do. So to answer your comment, there's nothing that's going to prohibit a seller from doing that. You have to educate them on the importance of it. You have to educate them on if they decide they don't want to, what will happen potentially if the buyer signed a buyer broker representation agreement, which they likely will, and they can't afford to pay the buyer's agent, then the deal could have a problem. And so the seller is going to have to negotiate with the seller's agent and the buyer's agent and put a contract together. This is all negotiation.
so do you see, so are you still saying that you definitely see the compensation field going away in the MLS, or you think
100%.
that's going to happen?
100%.
But then what's the purpose of the MLS? It's always
Cooperation.
Pardon me?
Cooperation.
Okay, so it's cooperation and
Absolutely. I think the fundamental of the MLS was already that anyway. Think about it this way. So if everyone's like, oh, the MLS is going to go away, that's a really bad idea. So your data is protected by the MLS, the way that the data is submitted out, the way that the rules are put in place so that everyone's operating off the same rule set. I was around in the industry when probably most people on this will not been here, but I remember the days of the MLS book because both my parents were real estate brokers. Going the other way is a horrific place to go. This whole idea of big brokers trying to hold on to their inventory is literally how we used to do it 40 years ago. And it's awful for the consumer. And if the DOJ and others are not careful, they're going to put this back in time. The MLS is extraordinarily important. Cooperation is extraordinarily important. The way that data is warehoused, the way that data is secured, all of those things are intact. The difference is an offer of compensation is no longer in the MLS. Do I think MLSs will consolidate? Yes. Do I think associations will consolidate? Yes. Candidly, they should. There should be less of them to begin with anyway. But I do think the importance of those two organizations are still intact, just differently. So, yeah.
So we've talked about where kind of NAR needs to go and where associations need to go. Brokers, what can you do now? And if you want to take it down to agent level as well.
Yeah. So brokers need to start training their people right now. Not tomorrow, like today. Like there needs to be.
I've been saying that for
yes.
forever.
Some things are not in place yet, but this is the time to do it. Look, I brought 415 of my franchise owners to Salt Lake City early last month, and started retraining. We're just finishing a 6-week training course for all of our associates and all of our brokerages to be retrained on this process, to learn how to talk to a seller about this potential future. It's not here yet, but it's coming. So learn to teach and talk about these things now. A buyer presentation, the most important thing everybody needs to have right now is a gorgeous buyer presentation. And here's what I tell people. Basically treat a buyer the same way you treat a seller, which we should have been doing like the past forever. Sit down with them, have a consult, explain what you do, articulate your value. NAR had a really good piece that came out. I genuinely give them credit for this. 179 things a buyer's agent does on an average transaction. You need to go get that piece and download it and include it. You need to learn to explain to them how long and sophisticated this transaction is, how much work you're going to do. And then you need to learn how to ask them to pay you compensation. By the way, I want to make a really important point. Prior to the way this is all going to shake out is the buyer's agent was compensated based upon the way the seller's agent negotiated the fee. Okay, so just think about it this way. Like you're being paid whatever the seller's agent negotiated. Well, in this post world I'm talking about, now the buyer's agent gets to dictate what they get paid. They get to articulate value in their own terms and dictate whatever fee structure that might actually be. So I will go on record as telling you right now, I actually think the good agents, you'll see compensation rates go up. not down. B, the reason is they're sitting down and clearly articulating their value to a buyer and can explain to them what they do. And if they're good, they'll get somebody to pay it, proven by every study I've ever read about how people are willing to pay for premium services. Do I think that, agents that aren't as good at it are going to struggle? Wholeheartedly. I think every broker should be expecting between 20 to 40% attrition over the next 24 months. Partially
wait a minute, would you repeat that?
20 to 40% attrition is what you should be expecting and budgeting for over the next 24 months. Now, that's not just because of the lawsuits. We're in horrible market conditions that aren't going to change anytime soon. So just look at the statistics. 2008 to 2010, we had 1.4 million realtors. We bottomed out at 1 million realtors. You're going to see people bottom out with the market conditions anyway. The lawsuits will add an additional flavor on top. So I'm saying somewhere between 20 and 40%. You need a budget for that. You need to train your people. We need to go get every negotiation book you've ever read. Go get those, train on them, get people to be better at negotiating, get people to be better at articulating value. And I firmly believe that we will be just fine, because at the end of the day, it's going to be clear who represents who. You're going to have plenty of ways to negotiate. I do also believe the seller will come up with paying compensation because they'll want to sell their house. They're not going to walk away from not selling their house over a small amount of money. It just isn't going to happen. And in the end, genuinely speaking, I've been a little bit reluctant to say this, long term, this industry will be in a much better spot, and there's no more investigations. There just isn't. Now, one final comment. I've had a lot of people ask me, do we become hourly? Well, no. Here's why. First of all, our IRS carve out in that specific statute where we're all 1099s, you can't charge hourly unless you all wanted to become
That's something that nobody's really talked about.
I've read it. So you can't charge hourly. So everyone's like, oh, we're going to become lawyers. I'm like, not unless you all want to employ everyone. So that ain't going to happen. I would also tell people that they're going, well, the American consumer will want to do a flat rate or a menu of services. I don't agree with those either. And I mean this as respectfully as possible, but most flat rate companies, if you look at the history of our industry, have all filed bankruptcy. I can name 3 off the top of my head: Foxtons, Purple Bricks, Rex, all gone, all tried that concept, all failed miserably. Menu of services, that may be the one that increases a little bit more, but I also have 2 examples of companies that have been around a long time and really aren't any significant player anymore, and that's assist to sell and help you sell. These aren't new business models. So what I'm trying to kind of articulate is just start planning for this right now. Train your people on how to do these things. This is all going to shake out. This is all going to settle out. There's going to be money that we're going to have to pay. And if it's a couple grand a person, just thank anybody that you want to thank that that's the only amount you had to pay in these cases. And we come up with a solution and we move forward. The plaintiff is not going to win if their intent ever was to dismantle our industry. They will lose miserably because this is going to just shift and we're going to adapt, and the consumer wants representation. We just have to adapt with it. So
any suggestions for agents? I mean, take training, but what else?
Same thing. Got to get your buyer presentation together, learn to work on how you would write the terms in a purchase agreement for the seller to pay you directly or a credit back. States are going to operate a little different, to be clear with my words. So you're going to have to work around some of those details. Put pressure on your local associations to get buyer broker representation agreements put in place as soon as possible. It takes time to work through that legislatively. And candidly, you need to talk to NAR about settling these cases. That's where we need to go at this point in time. As I mentioned, people didn't catch it. The plaintiffs have already filed another case against other major brokerages: Compass, Howard Hanna, United, EXP. They're all named. Everyone else is going to get named as well unless we settle these cases out.
So where are we a year from now, James?
I think the vision of what I just laid out is where we are a year from now. I think compensation in the MLS is gone. I think that we have an entirely new way that we articulate value to consumers. I think buyers agents get better at what they do. I think there's a clear establishment of who represents who. I think some of the ways we do business, there's like 4 states that do transaction broker. That's going to be a really difficult transition in those states. Florida, I think Louisiana is one. Some of that's going to get questioned and certainly looked at. I think a big hot button topic, not to stir the pot, but I think a big hot button topic in 12 months is dual agency. That's the next That's the next piece that we're going to have some deep conversations on. And I am very, very, very blunt and clear about my position. I think dual agency should be banned, not in the same brokerage, the same agent representing both sides of the transaction. I've been very clear about those opinions. They're unpopular in some circles. That's fine. 9 states currently ban dual agency already as it is. I think you will see that become a much bigger topic, so that, again, the DOJ and FTC wants to see a clear separation on who you represent. That is, in my opinion, going to be the next big piece that will come to topic of conversation. Right now, associations need to work on buyer broker representation agreements. That'll be the next hot button issue. So
just as an aside on that, the agency laws in most states are very clear on this. The agency is like Coldwell Banker, Keller Williams, NextHome, whoever it is, that's the agency. So that would be not doing deals within the same company or in the
agreed.
same location.
And the other question would be, how do you deal with teams? So I'm not suggesting that's a topic for today, but I certainly think that's going to be a major topic of discussion at some point. I was talking to an E&O provider, and the number, ignore the statistic because most statistics are made up on the spot anyway, but she did say to me that a majority of E&O claims revolve around dual agency.
So it's going away probably. And when I interviewed you before, you talked about issues with E&O insurance. Could you just elaborate on that? Because apparently everybody may think that they're covered, but if it's antitrust, they're not. Could you elaborate on that, please?
Yeah, so your E&O policy, your D&O policy, and your general liability policies all have exclusions in them unless you paid an additional fee, which nobody would have done. I should say nobody, that's extreme. Someone probably did, but most people don't. Antitrust claims, which is what these are in these class action cases, are excluded from coverage. What that means is maybe you might have coverage for lawyers' fees. You might. That's pretty rare as well. But certainly any type of damages is not covered by your insurance. So to put that bluntly, is most of you will have to pay out of pocket for your lawyers, and any damages you'd have to pay out of pocket for as well. And thank you for bringing that up, Bernice, which is why they need to settle these cases.
So anyway, final takeaway.
I would tell everyone to, number one, is try to pay attention to the sources that are giving you some really good details on this. Number two, try to ignore some of the headlines you're going to read, because it's designed to get readership. And I mean that respectfully to everyone, but this is actually not as big a thing if everybody just pays attention to what I just went through, how you restructure, getting better at explaining what you do, talking about how to negotiate. I don't see a future where all of a sudden buyer representation goes away. Everyone keeps talking about that. And I'm like, where in the planet does every person wake up and want to sell their own house? You'd think that would have happened with the advent of the internet. A fun stat for you, by the way, in 2001, buyer's agents were only used 69% of the time. So this is before Zillow and for everybody else. Now it's 88% of the time. So you'd think with the advent of all of this technology and all of this stuff, that agency would have gone away. It wouldn't use realtors, but ironically, it's gone the other way. So super important just to remember that this is just a learning moment for us. It's not ideal, but we're going to move it. We're going to adapt, focus on helping buyers, focus on helping sellers, do what you already do really well, just shift your business, and you'll continue to be the main point of contact and the center of the real estate transaction. That's my view.
Wow, James. What a day, 1.78 billion. And the huge takeaway here is for everybody to calm down, understand what's going to happen and what you need to do and the steps you need to take now to move forward. We've been, thank you, James. We've been visiting with James Dwiggins, the founder and CEO of NextHome. And he's been 100% right in his predictions. And I think he's spot on today. James, thank you for being with us today.
Thanks for having me. If anybody has any questions, they can reach out to me too. I'm happy to answer them.